enforcement, and the implications for inappropriate partisan influence, the legal and prudential limits of influence on the Department of Justice by the President and other actors in the executive branch, as well as in Congress, the lawful and appropriate scope of prosecutorial discretion, and finally, the role that growth in the breadth and coverage of federal criminal statutes may be playing in the present circumstances. We are fortunate to have, and honored, frankly, to have 4 extraordinary panelists to cover this topic. They're all well known, I would assume, to this audience. Judge Michael Mukasey, former Attorney General of the United States. Gary Grindler, former Acting Deputy Attorney General of the United States. Ken Weinstein, former Assistant Attorney General in charge of the National Security Division and U.S. Attorney. And Andrew McCarthy, former Chief Assistant United States Attorney in the Southern District of New York, as well as a noted writer and commentator. So I welcome each of them, and we look forward to a dialogue today on these hot topics and conversations. To get started and to set the stage, if you don't mind, Judge Mukasey, I'll turn to you in the first instance and ask you whether and to what degree you believe that these conversations about these politically sensitive criminal investigations and prosecutions in recent years raise concerns about partisanship and institutional hubris, and whether these concerns and criticisms and observations are well-founded.
Well, I can't speak to, obviously, all the criticisms that have been made and all the conversations that have been held. I can say that certainly it's appropriate to have the conversations. I'm more concerned, frankly, with institutional hubris, given what's gone on recently, than I am with the question of the limits of what a prosecutor can and should do with respect to investigating people who are perceived to be political adversaries of the administration that's then in control. Obviously, the fact that somebody is an adversary of an administration does not confer immunity on that person. In addition, one has to be very careful in conducting investigation, not simply in the result, but rather in announcing the existence of the investigation at all. Generally, the Bureau and the Department do not disclose the existence of investigations until it's time to bring a charge, or not. I think that we've had problems with that in recent years, largely but not entirely because of leaks. Sometimes it's impossible to proceed with an investigation without taking a step that finds its way into the press. But generally, one should avoid that. If one avoids it, I don't see that anyone is limited in conducting investigations simply because the person being investigated is a political adversary. Ultimately, the political appointees bear political responsibility for the existence of the outcome of an investigation. And so far as, I'm happy to talk about White House Justice Department contacts, because we had some perception of impropriety before I took office, and we worked out procedures for controlling that when I was there, and as far as I know, they've held up pretty well since.
Thank you, Judge. Andy McCarthy, you've written a book, a bestseller, seemingly entitled "Ball of Collusion: The Plot to Rig an Election and Destroy a Presidency." That's a rather provocative title. I hope that's part of the reason your book has sold, and you chose it. what are your thoughts on this? Is the criticisms and concerns about politicization and decision making beyond just institutional hubris? What concerns do you have as an observer these days?
Yeah, a large part of the reason I wrote the book is because I hate being wrong, and for a long time, I maintained that a lot of the central allegation, particularly about abuse of the FISA process, was wrong. You know, I had people who I had commonly worked with over the years on national security issues who were insistent that that basically a political opposition research screed had been taken virtually in toto to the FISA court, and basically they slapped a caption on it and got FISA warrants. And I tried to patiently explain, as I observed the tinfoil hats on their heads, that that's not how the FBI works, and that what we'd ultimately find at the end of the rainbow was that they will have gone through the information that they took in, because we take information from everyone, right? We take information from some of the worst people. It's necessary to do that in some of the investigations of the worst criminal conduct. And what I told them was, what would end up happening is that you will have gotten 5 or 6 or 7 facts that they needed, and the FBI would do what the FBI always does and go to school on it. And by the time they got to the FISA court, it would be an FBI investigation, not political opposition research. And of course, I turned out to be wrong about that. A lot of what was used in the FISA court was uncorroborated, multiple hearsay, political opposition research. And it bothered me to be that wrong about something I thought I knew pretty well. And here I need to go back for a moment to the 1990s, where we had a very robust argument. It's so long ago and far away now that a lot of people have remembered it, but it was quite a thing at the time. And that was about the so-called wall, which impeded the cooperation between the criminal investigation side of the FBI's house and the foreign counterintelligence side. And there was a lot of concern back then that the foreign counterintelligence powers would be used or could be abused to basically steer criminal investigations under circumstances where there wasn't adequate evidence to have a criminal investigation. And you would just basically pretextually use these powers until you finally came up with some criminal evidence, at which point you could then pounce. There was a lot of concern back then that could happen. And at the time, it was really only conjectural. We didn't have any real evidence of it's happening. And I maintained, and this is what I'm sort of annoyed at myself about, I maintained for very vigorously that just simply could never happen, because there were so many rungs of approval at the FBI and the Justice Department that you would have to go through, that assuming that you had a rogue agent, it would be much easier to fabricate the fundaments of a criminal investigation and go the criminal route than try to fabricate a national security angle. And that turns out to have been wrong. I think I owe an apology to the people who I made that argument to in the 1990s, even though we sadly felt pretty vindicated about it after 9/11. So the only thing I can conclude from all of this is that we're not effectively, I don't know if we don't have the guardrails in place, or if we have them, but they're only nominally understood, and they're not effectively applied. But I do think, the FBI and the Justice Department had a lot of bad luck in the last 4 or 5 years, because some of these investigations, the Clinton emails investigation in particular, fell into their lap. It was unavoidable that they were enmeshed in the politics of the 2016 election. But as far as the second investigation is concerned, it seems to me that the safeguards that are supposed to be in place to make sure that abuses like that don't happen fail. And the most important thing going forward is not to keep using them against each other or continue this cycle. It's to try to figure out what went wrong and fix it.
Gary Grindler, you've served in 2 different Democratic administrations as a political appointee after many years as a career AUSA. How do you see politics and institutional hubris in the present Justice Department and the present atmosphere around it? And what do you see as the dividing line, I guess, between legitimate investigation and prosecution of politically sensitive matters and inappropriate partisan motives driving investigations or prosecutions?
Well, one of the most significant decisions that the Department of Justice makes, I think, is to initiate the investigation. And the comment made about keeping those investigations confidential is of great significance, because it's very easy for someone who wants to embrace one political adversary versus the other can effectuate considerable damage by leaking information about an existing investigation. So I think one of the focuses that has to take place here is making the decision to initiate an investigation is critically important. It doesn't have with it the requirements even of probable cause at the outset of the investigation. And you see that the public release has damage. The investigation of the Clinton emails that was announced, many people have criticized that by suggesting that that announcement was not appropriate, and it had impact, and it was easy to do. So you have to think about that and the processes you need in place to try to go ahead and investigate those people that deserve to be investigated, regardless of their party, but protected from public disclosure. The timing of that particular matter was significant, of course, because you were in the midst of a presidential election. But those are, and on a smaller scale, we faced decisions about initiation of investigation during the political season where one candidate was trying to convince the FBI to initiate an investigation of the adversary, in one case even to wear a wire and have a meeting with the other candidate. And those decisions had to be made. Once made, though, someone was going to leak it. And so the processes for that are very, very important.
Ken, you served as the Assistant Attorney General in charge of the National Security Division, and obviously a number of these investigations have involved intelligence equities and use of the FISA process as in addition to other criminal investigative techniques. From your perspective and that vantage point, how do you see the department putting in, I guess, and to what degree do you believe that the political and institutional hubris risks play a part in decision-making to open investigations, particularly where there are intelligence equities in the mix?
Yeah, I think actually you put your finger on an important characteristic of some of the matters that have come to the fore over the last 4 or 5 years, which is that there's an intelligence dimension to them. And that complicates things in a number of ways, because you now have, in deciding what to disclose, what not to disclose, what to act on, what not to act on, which is always something that's heavily scrutinized either at the time or later on for the possibility of political influence. You then throw in the further consideration that you're dealing with very sensitive sources and methods that need to be protected, in their own right. And so oftentimes then you'll have the relevant institution, whether it's an intelligence community agency or the Justice Department, either refusing to use or refusing to disclose information that American people might expect to hear in a criminal process because it's classified or it relates to sensitive sources and methods. So that's a different dimension that we've seen play out, especially in the Russia investigation. I think a different complication that arises from the fact that there are sort of intelligence dimensions to some of these cases is that we're all accustomed, whether we're criminal lawyers or just lay people, we sort of have an understanding of the predication that's used in the criminal process. Probable cause, preponderance of evidence, beyond a reasonable doubt. That's just something that we've internalized as a people. And we use different standards when it comes to using intelligence tools. And it's sort of be a gross generalization to say lesser standards, but we use different standards. I think Andy was sort of referencing that when he talked about FISAs, that it's a different process to get a FISA, Foreign Intelligence Surveillance Act order, than it is to get an Article 3 wiretap. So Judge McCasey reviewed countless wiretap applications as a judge. I probably brought one to him myself. And it's intuitive to him as to what is required for that. It's different when it comes to FISA. And so one of the challenges has been, as the FISA process has been publicly disclosed, the process that Andy has written about in the Russian investigation, people, I think, have been ill-equipped to sort of judge whether there was sufficient predication. And I actually think the department has done not a very good job of explaining, what that predication is and what it should have been. So these are just things to keep in mind, that I think it was sort of a perfect storm, this Russian investigation, in the sense that it was obviously highly political, highly antagonistic on all sides. It then, because of that antagonism, you then saw the institution, acting as an institution. You talked about institutional hubris. There's just the human reaction of institutions and their people. But then in addition, you had what is sort of foreign territory for a lot of people. And I think there was somewhat of a lack of understanding. And so I'm glad, and I've not read your book yet, but I'm going to. So I'm glad that you've teased this out, because I think that'd be a real service to the American people who are trying to make, trying to really get a clear understanding of what didn't happen, once hopefully the political smoke clears.
I'll also tell you that I reviewed countless FISA applications as well when I was AG, and there was no problem with most of them. I say most because one or two did get marked return to sender, and one or two did get marked return to sender by the court. It wasn't a question of denial; it was a question of what about this and what about that. So it was an iterative process.
I guess I would also, though, go back to the point of on predication. Here I think is what the difficulty is, and this is really more of a judgment thing than anything that you could capture in the most perfect regulation that you can write, which is we necessarily need to have predication at a low level so that we can act in circumstances, especially as Ken is talking about, in the intelligence sphere, where we're dealing with national security threats to the United States. We can't wait until things ripen before we act. So it necessarily has to be a low level of predication. But that creates a much bigger danger that you could abuse these powers in the criminal context without what would be the normal predication that you would have in a criminal investigation. And the other thing with criminal investigations, all of us who pursued them know, is that, they're fairly finite in the sense that, at a certain point, you either have it or you don't. And every case in a U.S. Attorney's Office or the Justice Department broadly, but certainly in the U.S. Attorney's Office, is competing with every other case for resources. You don't have time to, string things out forever. You either pursue the case or you move on. And the thing they were concerned about in the mid 90s, which seems to have been the problem here, is that you would use not only the low level of predication, but the black box of everything being classified on the national security side to string out a criminal investigation under circumstances where it didn't really merit being strung out. And the thing that's supposed to prevent that from happening is, I think, adult supervision. I mean, we can write as many regulations as you'd like to write, but unless you have people with good judgment who say, this is not the kind of thing that we do, we don't take unverified information to the FISA court. We run it down before we go there. I just don't. I don't know what's to be done about the problem of pretextual use of the national security powers in the absence of having. I think the lessons learned here have to be that there has to be some kind of a presumption against using those powers in our political context, especially our electoral context, and there has to be higher guardrails or multiple levels of supervision where we stop that from happening at an early time and make sure that we're not using these powers in a way that affect politics, because it's not good. It's bad. It's terrible for the politics, but it's also awful for the Justice Department and the FBI to be enmeshed in it.
So let's deal with, I guess, the constitutional dimension and the sort of true legal dimension of all this. I think what I hear from the four of you who sort of range across the political spectrum a bit, but all obviously DOJ alum, is that you all believe that politics should not play and partisan politics should not play a role in decision making, and that good judgment is critical in terms of discerning what's a good investigation to begin and what's not, as a theoretical matter. Obviously, Article 2 of the Constitution vests all executive power in the President of the United States, and presumably that means that ultimately, as a constitutional matter, all prosecutorial power emanates from the President and resides with the President. Judge Mukasey, you talked a little bit about some of the limits that you observed when you came aboard as Attorney General. There's obviously a history stemming from the lessons post-Watergate. But let me just start. Is there a distinction between the legal limits of presidential influence on the Department of Justice and prudential limits on the power of the president? And if so, where do we draw that line as a legal matter versus a prudential matter, and why?
I don't know that it's possible to draw a legal line. As you said, the Article 2 puts the executive power in the hands of the president. And when the Attorney General exercises authority, he's exercising the president's authority, not his own. The only way to assure that the decisions that are made with reasonable safeguards in place is to assure that when, as, and if there's any attempt by a president to get into a particular case, that goes to the people who within the department who are politically responsive. and that they deal with the president on that basis. They will either pursue something or not pursue it, depending on their inclination and their ability to withstand the pressure. In an extreme case, obviously, they can either resign or be fired. Just to put a bit of a point on it, I did get one such request to show up at the White House to answer for something in a particular case, and I did, and we had a conversation. It was not with the president; it was with a member of the staff, and it was clear that that person was talking for the president. And I went back to the department, and we proceeded as we had before. I didn't get fired, so that, I think, is the way it's supposed to work.
Gary Grindler, you served as the Principal Associate Deputy Attorney General. At least my memory is that in many instances, the Deputy Attorney General, and particularly the Principal Associate, the so-called PAYDAG, serves, at least under some of the prudential norms in the department, as the go-between, if you will, between the White House and the political powers at the White House and the department. How has that worked and not worked in your observation over the years, and to what degree is that, I guess, enough of a governor, if you will, on ensuring the right balance between political accountability to the American people and the exercise of prosecutorial discretion free from partisan influence?
Well, as you know, there's a memoranda that has addressed the communications between the White House and the Department of Justice, and in my experience, it was pretty much adhered to. I mean, we would have discussions about public indictments and prosecutions in terms of what is public, but in terms of investigations, we were pretty scrupulous to avoid discussions, with exceptions. And one of the big exceptions is national security issues. A investigation, espionage investigation, that's going to have a direct impact on the relations with another nation, or even circumstances in which a prisoner exchange might be something that's important to consider, or an indictment that's going to come down that will have some profound impact on the financial markets. There were exceptions where some disclosures were made of pending matters, but it was rare. And there seemed to be a respect for that. And so I was, for the most part, satisfied with, at least in my experience, the adherence to getting involved with the White House when the case really implicated, serious interests of the United States that the president should be involved with. But in the overwhelming majority of cases, we would not talk about them.
Ken, in terms of, from an NSD perspective, with an exception that essentially allows national security implications to potentially, sort of reduce the threshold for communications with the White House and the presidency, and given the recent investigations that seem to arise in that context, should that exception to the general rule be examined? And if so, what do you do about it, given the importance of national security, but given the importance of, normatively speaking, of keeping some distance between political actors and the exercise and prosecutors who are exercising judgments in particular criminal investigations and cases?
Yeah, look, it's a good question. And the traditional rule, the memo that has been sort of put in place that Gary referenced, it's primarily designed to prevent the White House from calling over, any White House from calling over and saying, hey, I understand you're investigating Congressman Jones, congressman of our party out in state X. Why don't you just not pursue that investigation? We really think it's not good. Obviously, that's the kind of communication you don't want. And that's usually in the criminal context. Especially after 9/11, it became very clear that that kind of barrier to communication, and it's very structured. It goes through a particular, whether it's the PAYDAG, it used to be the iconic David, who was the person designated to sort of receive input about ongoing matters from the White House. There's a process that's to be followed. That just doesn't work in the national security context. And post 9/11, we really saw why. So Andy talked about the lowering of the wall after 9/11 that had separated culturally in many ways, regulatorily, but also by practice, the intelligence assets of our government from the law enforcement assets of our government. And that was really crippling and helped to lead to 9/11 happening without us detecting it first, because there were criminal agents from the FBI who couldn't share what they knew about terrorists who are, criminal suspects, criminal targets. They couldn't share information with the intelligence agents of the FBI who were investigating the same people as intelligence targets as opposed to criminal targets. So that wall came down. There can now be sharing across within the FBI, but also between the intelligence community and law enforcement about these targets that they hold in common, like spies. Spies are an intelligence threat, but they're also criminal suspects. Terrorists, foreign terrorists, the same thing. Foreign cyber bad actors, the same thing. And that needs to be coordinated at the interagency level, which is run out of the White House. And the classic scenario is if you have a hot threat investigation, let's say we detected a cell here in the United States, the intelligence community might not want to take it down immediately, because the longer once you detect a cell, the longer you can monitor it, the more you learn not only about those bad actors, but the people that they're related to, right? So longer you leave it out there, the more intelligence you get. Law enforcement might be looking at it differently, thinking, hey, we need to take these guys down. We have a case that we can perfect. We can put them away for 20 years each. That's a decision that has to be made at the interagency level. So that's communication with the White House, oftentimes in the White House, in the Situation Room, about possible criminal charges where the political folks in the White House are fully engaged and need to be fully engaged. So I don't, to the extent that your question goes to, isn't this a predicament? Isn't this a dilemma that we're trying to prevent White House influence on what could become criminal cases? And now we're seeing that happen in the national security context. So shouldn't we have some sort of prohibition on that kind of communication in the national security context? I just don't think that's doable. I think it's just so critical that we have that coordination. And I think one of the greatest things that's happened since 9/11 is that coordination, is the ability for, the general counsel of the CIA to call up the head of the National Security Division, John Demers, and say, hey, let's talk through how we're going to manage this matter. We've got our agents, we got folks looking at this terrorist cell. You've got FBI agents doing the same. How do we coordinate? So I think in short, that just isn't going to be feasible to do.
Can I just say, I was glad about two things about what Ken just said. First of all, the bit about no prohibition. I emphatically agree with that. I think my concerns are more along the lines of what can we do internally to raise questions at a high enough level and go slow when there are competing concerns, especially with the law enforcement concerns. But I'm not talking about any kind of a regulatory prohibition at all. And the second thing, Ken mentioned culture, which is a great word to use in this context, because I can speak personally, not from the main justice angle of this, but from the criminal prosecution angle of it. I experienced culture shock in 1993 when we end up having an internal debate in the Justice Department about whether to indict the blind sheikh or not. And it was the first time, I mean, maybe it had come up in a sliver in other cases I've been involved in, but this was the first time I had ever had a case where, you know, the ethos of the Justice Department is we're entitled to everybody's evidence and nothing is more important than our cases and nobody is above the law. And we love to say all that stuff. And I think, you know, 99.9% of the time it's true. But you suddenly find that there actually are other considerations, and they are not only legitimate considerations, they're serious national security considerations that are more important than prosecutions in some contexts. So when we had to have this debate about whether to bring charges or not, it wasn't just a matter of whether we had enough evidence to charge. It turned out that we had to look at both, especially on the State Department end and the intelligence end, what was the benefit versus the downside to the United States of bringing these charges under these circumstances, and what interests of ours, particularly security interests overseas, were going to be affected if we went ahead with the case. And the only reason I raise this is I think, and it seems to me that this is evident in a lot of, certainly the coverage and the commentary about the investigations over the last few years. There is an ethos in the Justice Department that nothing is more important than our prosecutions. And again, most of the time that's true, but I don't think that we're sensitive enough to, number one, how much these investigations compromise an administration's capacity to govern when they're corruption investigations that are aimed at the administration. And secondly, it simply is a fact that even if you're not talking about executive corruption, there are a lot of interests that are at stake that we have to deal with that are more important occasionally than our prosecutions. And I just don't think that we necessarily do a good job of communicating that.
So let's talk about some remarks recently that Attorney General Barr made in September at Hillsdale College. And in his remarks, he made really 2 points that I want to highlight here. He first said that the most basic check on prosecutorial power is politics. And he said it's counterintuitive to say that, as we rightly strive to maintain an apolitical system of criminal justice, but political accountability, politics, is what ultimately ensures our system does its work fairly and with proper recognition of the many interests and values at stake. And he spoke and then said the men and women who have the ultimate authority in the Justice Department are thus the ones on whom our elected officials have conferred that responsibility by presidential appointment and Senate confirmation. That blessing by the 2 political branches of government gives these officials democratic legitimacy that career officials simply do not possess. One of the seeming themes of a lot of the commentary that I've read in recent years would suggest just the polar opposite, that it's the career officials that are the apolitical players and whose judgment should be relied upon in these highly sensitive political investigations, particularly if the Justice Department is looking at political actors and particularly looking at personnel in the White House. And yet, Attorney General Barr certainly seems to be arguing that, in fact, it is the political appointees themselves of the department that are, frankly, the truest expression, I guess, of the American electoral process and therefore the will of the American people. How do we square that circle, Judge Mukasey?
Well, I think I come out entirely on the side of the Attorney General on this one. It is possible for career people, however well-intentioned, to become married to their cases and to their positions in those cases, regardless of whether that happens or not. I think that ultimately, as I said before, the authority that's wielded here is an executive authority, and the people who are politically responsive and will pay the price politically if power is wielded improvidently are the people who have to have ultimate authority. To say that we're going to delegate this to or prefer the word of career people simply because they are career people, I think is a grave mistake.
Gary Grindler, obviously two can tango here. If depending on where you sit politically, you may be very happy knowing that political appointees are making the decisions on a case. Then again, if you believe you're on the opposite end of the political spectrum from those political appointed officials, you may fear the worst. In your experience, how, as a political appointee, do you manage for that? And what can the department do, the political actors, the political appointees in the department do to try to avoid not only the substantive influence of politics, but the appearance of partisan motive in the situation in which they're being asked to make decisions in highly sensitive investigations that involve political players or political equities in some fashion?
Well, I don't know that I would have worded it the way the Attorney General worded it, but I believe in the notion that the leadership of the department, even in the context of making decisions in criminal matters, should be the ultimate decision-making for sensitive matters should be with the politically appointed leadership. But I also, and for the reason already stated, that career prosecutors are not immune from having viewpoints on things, getting highly invested in a case, or attracted by the potential notoriety of the case that could make them approach it more aggressively than is appropriate. So, but I think as political leadership, and I think it is a process that at the department that has worked, that you need to seek the input from the career line attorneys who have devoted their time and attention to the case, but to their supervisors, their career supervisors, and up the line, because you want to show and demonstrate that you're considering all of the factual and legal merits issues when you come to a decision. But at the end of the day, I think it was referred to as adult leadership, someone's got to make a decision on these sensitive cases, and some of the issues are incredibly complex and difficult. But I think that the process by which those decisions are teed up, or those cases are teed up for decision, is the way you get credibility, hopefully with the career people and with the public.
Ken, let me pose what I think is kind of a hard question. Surveys that I read about career DOJ personnel suggest that the majority of DOJ personnel who make political contributions tend to do so to one political party over the other. Obviously, such political activity is protected, and the right of these individuals to have political views is protected like any other American. But to what degree does that kind of free will behavior by career personnel, to what degree is that a factor that may be rightly considered by a supervisor in staffing politically sensitive investigations or cases? To what degree should that be ignored? How do we address that as we think about politics and the Department of Justice?
Oh, look, that's a good question. So, you get at sort of the fundamental issue here is you've got people who have decided political views, and they are career people whose job it is to exercise prosecutorial discretion completely regardless of politics. And, I think there is a sense in this country, and I think one of the unfortunate effects of the last couple of years has been a sense on the part of many that people cannot actually put their politics aside and do their job apolitically. Now, those of us, many of us on this call, are longtime AUSAs who grew up in a culture which didn't consider politics. And especially in the big city offices, it's just, it's if you start acting and speaking in too partisan a way, it actually is sort of atonal. It doesn't work in a U.S. attorney's office because people who are career folks pride themselves on not being political because they know how devastating it can be to the reputation of the Justice Department, the reputation of the office and the individual if you are seen as driven by, things other than the facts and law that relate to that particular case. And I often say, now I was the U.S. attorney in the D.C. office, and that's probably the least political office in the country because it has the DA side. It does a lot of street crimes, and there's no political dimension to those cases. But we had 330 prosecutors. I literally think I was there for 12 years. I might know the political affiliation of about 3 of my friends. It just wasn't an issue that we discussed. I mean, we talked politics, but we didn't talk about our partisan loyalties. And so that culture still exists in DOJ, and people still, I think, are proud to believe in it. And I think actually it's one of the underpinnings of morale in DOJ that prosecutors and all staff sort of feel like they're doing things that are it's God's work. It's based on justice and not based on the whim of one person or one person's political predilections. That being said, to your question, you can't ignore the fact that somebody might have political leanings and make sure, for a couple of reasons. One, you have to make sure that person is not going to allow his or her decision-making to be influenced. And there are some people that try as they might, they cannot put their politics aside. But even more importantly, it's the perception. And it sort of foundational to the department's ability to have credibility and be effective is the public perception that is doing things based on the facts and law, and is equal and blind in the way it dispenses justice. And if there's a perception that one U.S. attorney hires only Democrats or hires only Republicans or declines cases against Democrats, goes after cases that involve Republicans, that's going to catch up to them. And, I think that a number of the questions that have been asked over the last, 20 years since I've been really tracking all these political issues from campaign finance through the Hillary emails through the more recent ones. The unfortunate thing is the belief on the part of some that prosecutors really cannot put their politics aside. I might be Pollyannish, but I actually believe that they can and that they largely do, actually. So I would hate to see any kind of litmus test be applied to the hiring or staffing practices of the Department of Justice. We want people who are passionate about politics one way or the other. We just want to make sure they don't let that, because that shows that they care, right? It shows they care about our country. They care about the future of our country. They're therefore going to care about the mission of the department. That's fine. We just need to make sure that we are conducting very careful supervision, and that the leadership, both career leadership and even more importantly, the political leadership, are very attuned to the perception of politicization. And I'm worried that that perception has become ingrained and is being used sort of as a weapon both directions. So I really worry about the future of the department given that state of play.
Andy, you've been covering, I know, through your regular appearances on the John Batchelor show, and been discussing a lot of the decision making by prosecutors in a number of the highly sensitive investigations that have generated such national discussion and debate. To what degree could some of the criticisms of the decisions and the decision making in terms of the perception of bias been avoided based on your observations of the way some of these investigations were staffed and managed?
Well, my experience, not surprisingly, is the same as Ken's, which is that in the vast majority of our cases, what we do is a professional clinical exercise. We figure out what the law is, we see what facts we can prove, and that's the job. Having been a conservative lawyer in Manhattan, where virtually all my friends, many of my friends in the office were liberal Democrats. As Ken just said, politics might be an issue when you're sitting around, having a couple of beers after work on a Friday, but it doesn't have any bearing on the job day to day. And I had no problem in 20 years as a prosecutor working with people who had very different political views than I did, because that stuff got checked at the door and you do your job in the courtroom. But I think, politics is part of a bag of stuff that occasionally has a bearing because of the nature of particular cases. And it's not the only thing. I mean, a lot of times we have to do, because the appearance of impropriety is our standard for maintaining the integrity of the system. There's a lot of things that come up that can give you a conflict. It's not just your political attitudes. And we have to go through that in every single case where there could be a perception problem. So it just seems to me that the rule of reason should apply, that no one wants to say your constitutionally protected ability or right to participate actively and vigorously in politics should at all be tamped down on. But you don't belong in a big political investigation then. I mean, if you have a situation where, there's a fraught political nature to the investigation, I can talk about this personally. Every now and then, because I'm out publicly doing, the gas bag important work that I do, my name gets bandied about when somebody needs a special counsel, or at least comes up in public discussion that there should be a special counsel. And it's come up on Democratic investigations, it's come up in Republican investigations. And I always say the same thing, which is, first of all, I'm fortunate enough to be able to make a living without having to work. So what do I want to get involved in that for? But more to the point, the public does not want a prosecutor in one of these fraught investigations who's been out in the peanut gallery telling everybody what they think of the case and what they, where it's going. Even if you're trying to do that, and I do try to do this in as fair-minded a way that you can do it and try to be neutral about it, you don't want a prosecutor who's been involved in that process. That's just, to me, that's just common sense. So I think that, your political attitudes ought to be part of the baggage that you bring to any case, that if it turns out to be a case where that's relevant, you either need to factor that in, and if you don't perceive the need to recuse yourself, then somebody has to be in a position to disqualify you. But I don't think there should ever be a bright line rule that just because what we're talking about is constitutionally protected activity, that means we have to put it in a black box and we can't consider the prosecutor's attitudes about that, because we have a higher obligation to the integrity of the judicial process and to make sure that the public perception of these investigations, which are the most wrought investigations that we or among the most wrought investigations that we have to deal with, we have to make sure that that is on the up and up and that the public perceives it as on the up and up.
Judge Mukasey, you headed up the official corruption unit back in your day and at the line level. And obviously, as Attorney General, you oversaw a lot of politically sensitive investigations that were briefed up to you. To what degree then do career prosecutors and officials who have a public record of a partisan leaning differ, and should they be treated differently in any way in terms of staffing and decision making as compared to the political appointees in such sensitive investigations?
Well, obviously, I think it depends on the profile of the particular prosecutor. Although I should tell you that the corruption cases that I handled principally, apart from one congressional prosecution, involved principally dishonest law enforcement agents. That was official corruption in those days. It's gone, obviously, it's matured to a certain degree since. So far as assigning people, it again, I think the tone comes from the top. And if the norm, as Ken described it and as Andy described it, is that you check that stuff at the door, then you should have no hesitation about assigning just about anybody. But obviously, people who have a high profile politically, who come to a prosecutor's office, simply can't participate in politically sensitive cases, particularly those that engage the activities that they've been involved in. That's just common sense. Also, we've been talking about guardrails and principles and regulations as if they were self-enforcing. They're not. You can draft the most exquisite regulation, and it won't enforce itself. You can speak of something as a guardrail. Guardrail it's a nice image, but it's a passive control that does enforce itself. What we're talking about here are not guardrails, because there are no processes that are going to enforce themselves. Ultimately, it's going to take people with good judgment who subscribe to the kinds of norms that Ken and Andy have been talking about. And if they're not there, then all the regulations and guardrails in the world aren't going to do you any good.
Attorney General Barr also argued in his Hillsdale remarks, made the point that individual prosecutors can become, quote, headhunters consumed with taking down their target, unquote. How does the department manage for the perception that could be the case? And when is a zealous advocate on behalf of on behalf of the department in a criminal investigation, or frankly in looking at things from a counterintelligence standpoint, cross over from simply a good faith desire to ensure that people are held accountable for unlawful behavior and a sort of inexhaustible investigation of an individual in search of a crime. I'll turn to you, Andy. I think you've obviously, in some of your writings and commentaries, have spoken a bit on this.
I think this goes back to what we've been discussing, and to me, it's more of a matter of common sense. If you have somebody who's handling a prosecution, who's appropriately handling a prosecution, meaning you don't have any reason to doubt or suspect, that there's any political taint, there's no conflict of interest, then I think if I'm understanding your question correctly, I think you just, you do your job zealously, and you do it measured by whatever the demands of the investigation are.
Ken, you made the point a moment ago that you thought you expressed great concern that there's perception in the United States today that the department has not been exercising its authority free from political bias. And you're concerned about that institutionally for the department and frankly for the rule of law in the United States. How do you address that, given that both the partisans on each side of the political equation these days accuse the other side of engaging in basically the kind of mirror opposite of behavior? To what degree, if we move into if there's a new attorney general, how does that new attorney general write that in a way that doesn't just simply come across as saying, well, we won, so therefore now we get to exercise our authority consistent with the way we like, and ratify essentially only one side of the partisan perceptions?
Yeah, look, that's a good question. And just to go back to my earlier comments, they were that I was concerned, am concerned that the perception that DOJ is politicized is and can be very damaging to the future of the department and its effectiveness and its credibility. I'm not buying into the idea that it is politicized, under any type of administration. I actually think the culture is very strong. Are there places along the way where there questions should be asked and maybe there are missteps? Sure, but I think largely, as we all have agreed, 99.99% of what we do, what the department does, is done apolitically. But it's a very damaging perception, and the next administration and every administration needs to be very sensitive to that, because that's sort of first order of business, is protect the reputation of the department. And to give Judge McCasey some credit, he had to deal with a perception that had been created fairly unfairly, of politicization of certain aspects of the department before he came in. And one of the things that I was most admired about how he handled his entry into the department was he made very clear, regardless of what did or didn't happen before, whether it really was politicized or not, he went to great pains, at least as I saw it, to make it clear that he was about just doing the JOB, working with the career people. He was going to be politically responsive to the president, but he was going to make sure that everything was done sort of according to regular order. And that message got sent very quickly. And part of that was just character. Part of that was understanding the department. So the next person who comes in will have to do the same thing, and it's very important. But look, I guess I'm just sort of an eternally optimistic person. But I look at the department, I see, look, the career folks in the department get it. That most of them get it. That there's a political rank, and the political rank has the authority, in fact, the responsibility, the duty to supervise them. And so, if the career people, I decide I think this is a charge that should be brought in this case, and the political person pushes back and says, no, I see it differently. At the end of the day, the political person, the higher ranking supervisor gets to make the call. The attorney general gets to make the call. And so long as that call is made on sound, non-political reasoning, then so be it. That's the way it works. And back to your earlier question, I think it is important to mention that, some people have talked about how prosecutors get tunnel vision. They sort of get focused on their target, which means that they tend to see only the incriminating information and maybe not pay as much attention to the exculpatory information in an investigation. No question that happens. That's called human nature, right? You get set as a prosecutor, we're all type A people on, building a case, and the basic human instinct is to look at the information that helps you build the case more closely than the information that doesn't help you build the case. That's why we have, jobs of training in the department to make sure that we, turn over exculpatory information under Brady, why we're, constantly harping on the supervisors and their role at second guessing, not second guessing, but supervising the prosecutorial decisions of their line people, because we all fall victim to that. And so that's why we need supervision. And that's why I don't really worry when I hear about, a decision maybe at the higher levels of the department countermandering a judgment at the lower levels, so long as it's clear there was a rational basis for it. That's allowable. What is really damaging the department, though, is when a decision is made at the top levels, at the political levels, it overturns or is that it takes issue with a decision of the career folks, and the explanation is not made as to why that was, because that then undercuts the belief within the department that at the end of the day, we're operating on facts and law and not on politics. And that gets back to the perception. And so messaging, not only externally, but within the department, is so critical to maintaining morale and to maintaining the belief by everybody that we're about the facts of the law and not about politics.
I'm going to take a minute here and remind the audience that they can get continuing legal education credit for this panel presentation. The password is CRI 18, CRI 18, and I'll repeat that near the end so you can write it down again. Gary Grindler.
For a second.
Yeah, go ahead. Sure.
Just go back for a second to the headhunter problem and some of what Ken was talking about. One way that we guarded against that in the Southern District of New York, and I don't know whether this is done elsewhere, is to be very careful about not taking people right out of law school as prosecutors, and to be very careful of the people we took right off clerkships. Because if somebody has grown up for her or his entire life being told how smart they are and graduating magna cum this and summa cum that, and never having to say please and thank you and never having made mistakes, those people can be dangerous when they become prosecutors. And I think a little bit of maturity, a little bit of kicking around in the outside world is useful.
I second that. Gary Grindler, welcome back. I think we got you back on. We were, as we look to, dare I say, it would appear at this point, based on reporting, that Joe Biden has prevailed in the election. That's obviously subject to some continuing debate. But assuming we're going to have sometime in January a new attorney general, and given the fact that the partisans certainly perceive certain investigations as having been politically motivated for mirror opposite reasons, how should the next attorney general address that, recognizing that merely affirming his own, political party's worldview would have the effect of perpetuating this perception problem that Ken Weinstein mentioned earlier, I think, before you had some connection problems?
Well, I think you go back to the fundamentals that we've been talking about this afternoon. You need to take care with existing investigations and with new investigations, the kind of care that everyone has been talking about here, and make careful decisions, explain to the career people why you're making the decisions, and adhere to the principle that you are only going to prosecute someone if you have admissible evidence that will have the likelihood of establishing a conviction. I do want to add something else with respect to what I think I heard the tail end of, and that's the career people. I think we need to also think about the investigators, the people at the FBI and the Marshal Service, the DEA, the Secret Service, etc. Those investigators have a lot of power themselves. And we get back to the kinds of adult supervision you need in connection with initiating an investigation or deciding to go forward with it, or deciding either to prosecute or to decline. So this training and this preparation for the kinds of decisions that have to be made needs to be extended to the investigators. They're very important here because they get invested in these cases too. And if a case is going to be declined, they need to understand why it's being declined.
I'm going to open.
John, may I just make one point? I think one of the things that is hovering over all this that is worth noting is that the main checks on executive abuse are political, not legal. And a big part of the problem that we're dealing with here is Congress doesn't really do its job anymore as well as it should in terms of oversight. And as a result, it's kind of co-opted the department into doing not just the kind of criminal investigations that we would always do in a corruption context, but also, more broadly speaking, abuse of power investigations. And I think it's come up in a number of. It certainly came up in the Nixon impeachment. It came up in the Trump impeachment for sure. A lot of what's in the nature of abuse of power is not violations of the criminal code. And ordinarily, we investigate to see if there's a Title 18 or some other penal offense. If there's not, we can't prove it. It's, we don't have probable cause or at whatever stage, and then we don't have enough to make a case. We're done. We dismiss the case and we move on to the next thing. I think the department's gotten a lot of pressure from Congress to get enmeshed in politics because Congress does not do the kind of oversight that it needs to do. And as a result, the Justice Department is getting pulled into a lot of investigations where in ordinary criminal law contexts, it wouldn't proceed with those investigations. And I don't know exactly what you do about that, but some of this stuff, I think Attorney General Barr has said from the beginning of this current go-round in the job that the way to get politics out of the department and the department out of politics is if we get brought into something, we look. If there's a criminal violation, you pursue it in good faith. If there's not, then we're done. And there's got to be some better way to investigate abuse of power.
So I'm going to open the panel up to questions from the audience. I have a number that have shown up here, and see someone identifying themselves as Christopher Green with their hand raised. If you want to ask a question, obviously you need to use the raise hand button in the lower middle screen. And then when I call on you, you'll need to dial *9 to ask your question. So, Mr. Green, if you're on, what's your question for the panel?
So I'm not on the phone, but I think you can hear me. So,
yes, we can.
Okay, it seems to me that prosecutors' offices have a pretty good fit. Okay, I seem to have been muted. Okay, so it seems like prosecutors are a lot like out-of-control administrative agencies. And I wonder what all of you think about the idea of applying something like Overton Park or State Farm, or just, you know, the requirement that prosecutors explain themselves? It might not be to a court, but to somebody, something like that kind of review, applying that to prosecutorial discretion in general.
Well, Mr. Green, when you asked the question about explaining yourself, give me a for instance that you're thinking of that maybe the panel can address more directly.
So, I mean, it seems like you always have a question. You were pursuing these goals, but at what cost? So, at what point do these investigations become just absurd, going after people for technical violations that couldn't possibly be worthwhile? So, and that seems similar to the question: do you want I-40 to go through Overton Park in 1971? And they ultimately decided, no, the Memphis Zoo is important enough. We're going to make I-40 go around. And they just had to explain themselves. So prosecutors don't generally have to explain themselves. They can just, you know, decide to prosecute or decide not to prosecute. And they seem erratic in ways that the EPA and the other administrative agencies often seem erratic. So I'm just wondering if one of the ways that we use to control administrative agencies might be useful as applied to prosecutors too. So I hope that helps.
Okay, fair enough. Volunteer from the panel want to take this?
Yeah, I'll just say I think what prosecutors do is different because we're protecting the presumption of innocence. So you can't really explain yourself very often without getting into what became the big problem in the Hillary Clinton case, which is going public with evidence against people who are presumed to be innocent. And as far as checking what the Justice Department does, that's what the internal rungs of supervision and congressional oversight are for.
And then internally, in most U.S. attorneys' offices, there's an ongoing review process, or there should be, during the investigation, so that the prosecutor has to check in on a regular basis to give status updates and to talk about the facts and how things are being developed. And then you get back to the need for adult leadership. If it's a case that isn't a crime, then it needs to be stopped immediately. But I agree that and there are strong policy reasons for not walking out and announcing an investigation and talking about it. This is why we declined, because then you're implicating people that aren't being charged, and that needs to be kept confidential.
If I can just add here, John, that's a really good question. I think one way of answering it is to say that prosecutors do have to explain. They explain by having to secure a grand jury indictment, from a grand jury. That's explaining that they have sufficient evidence to meet the necessary standard, probable cause, and the belief that they'll be able to secure conviction at trial. But your question goes to a very valid point of, okay, what about explaining which cases you decide to bring and which cases you don't decide to bring? And I think we've just identified some structural obstacles to doing that in the criminal process, because the department doesn't and shouldn't say anything about anybody who was investigated and against whom a case was not brought. And so that makes it hard to then compare the facts of that case against the case for a person against whom a case was brought. So it's structurally sort of difficult. But that goes back to some of the oversight mechanisms that I think John was alluding to. I mean, you have congressional oversight, you have the Inspector General, and as you know, the Inspector General at DOJ in particular is very strong, and very, they don't balk at looking at any decision the department makes, no matter what level. You've got the Office of Professional Responsibility that reviews what lawyers do within the Justice Department. So there's a good bit of supervision looking at all aspects of practice, but in particular looking at whether politics intrudes in the decision making.
Next question, I'd like to ask Kelly Shackelford, who's raised a hand here to pose their question to the panel.
Thank you. My question is, I thought one of the worst sort of perception of justice issues over the past few years was sending 25 to 30 heavily armed officers to arrest Roger Stone, who's 80 and lives alone with his elderly wife. Who makes that kind of decision, and are there any consequences for that kind of abuse, and contacting CNN ahead of time to have them film it? That seemed way over the top, and I was just curious.
Well, who wants to take that one on? Let me ask the question a little bit less pejoratively and case specifically. In terms of how a warrant gets served and executed, and obviously we've seen historically situations of criticism of perp walks and other types of behaviors that put the accused, I guess, in a difficult spot. How do we weigh that against obviously the need for law enforcement safety in the execution of a search warrant? Who makes those decisions, and to what degree is the questions posed and the assumptions that fair, which is that in a white collar case with an individual who has no known prior criminal history, to what degree can the means used be, I guess, too much and undermine actually the perception that the person is being treated fairly in the way in which the execution of the warrant is being done? Anyone?
Yeah. I would just say in my experience, the FBI is, and whatever agency it is that you're dealing with, here it was the FBI, but it's sometimes other agencies. They're obviously very significantly involved. I would say, in my experience, more significantly involved than the U.S. attorney is in assessing the risk of whatever operation you're talking about, whether it's serving a search warrant, I guess is or an arrest warrant. And my inclination, for what it's worth, was always to defer to the agency, because they're the ones who are, number one, they're better at assessing these risks than the lawyers are, generally speaking. And also, they're the ones who have to go out and do the operation. Again, mistakes are going to be made because they're always made. And I'm always a little bit hesitant to comment on investigations. I always felt in my own investigations that I generally knew something that the public didn't know and that I couldn't say, and that if I was able to reveal that, people would have understood it a little better. It's true that sometimes there are things that are done that are over the top, but a lot of times when there's a show of force, it's done actually to prevent bad things from happening and accidents from happening, rather than to maximize the embarrassment or the danger.
Let me remind everyone about the CLE password. It's CRI18, CRI18. Let me call on Carla Westjohn, who had a question. Ms. Westjohn, I think you may be muted. All right, I'll move on to Mark Lamb. Mr. Lamb, are you able to pose your question?
I am. Can you all hear me?
We can, yes, sir.
So my question was specifically about the application of switching prosecutors' protection from absolute to a qualified immunity. And a lot of the conversation has gone around the internal protections that are listed within DOJ and the Office of the Inspector General for misconduct, but there have been instances of prosecutorial misconduct that I think would, and we grant qualified immunity to police officers who have to make, sort of life and death by the second decisions. What would be the argument against qualified immunity for prosecutors who make a deliberate and intentional act of misconduct?
All right. Well, who wants to volunteer for the question of prosecutorial immunity? I'll start for 1 second and just say this. I think that when it comes to intentional misconduct, which would fall within the question of potential relaxation, first of all, very high bar, right, to prove that a prosecutor was acting in complete bad faith. And frankly, those are the cases that are the most egregious. They are probably the most infrequent. I think, in my experience, at least, far more often are the cases where the prosecutor did not act in complete bad faith, but may have been very misguided. There certainly have been some noted investigations of prosecutorial decision-making. I can think of one during my tenure in the department in which a federal prosecutor was ultimately indicted for decisions that he made in conjunction with a terrorism investigation. He was acquitted at trial, notably. Obviously, the consequence of reducing immunity means it's usually a boon for malpractice insurers, and it certainly means a greater level of potential collateral actions against prosecutors. And obviously, as a policy matter, what you would have is presumably greater risk and slightly more risk-averse behavior amongst prosecutors. At least that's my observations on it as a technical matter, as a general matter rather than as a pure legal matter. But I think it would take, obviously, an act of Congress to change that standard as it presently exists.
I think also, it's Michael Mukasey, I think also that fear of either a civil judgment or a criminal prosecution is not the principal deterrent to prosecutorial misbehavior. Loss of professional stature and loss of a professional license is, and there's no immunity from that. So I think that usually operates as it should.
Okay, we've got time for one more question, and then we're going to close. Mr. Gilmore, James Gilmore, if you could pose your question quickly, please.
Sure. Can I be heard? I think I can.
Yes, sir.
Yeah, I'm Jim Gilmore. I'm an ambassador over here in Vienna, Austria, so I'm a lot later than you are right now. But I was also a defense lawyer, a prosecutor, and an attorney general. And I thought I might point out there are checks and balances on this system. First of all, my experience is the judges are watching you all the time to make sure that you're not guilty of misconduct or impropriety. And second, the press is always looking to see if there's some abuse of authority, because they love to print that stuff. And then so they'll be looking for you. And then third, and most importantly, is the bar and the ethics, because you're still an officer of the court. And if you are guilty of misconduct, there's nothing scarier than the bar coming and looking over it. I'm not sure about whether 1983 would apply as a check and balance on impropriety of use of discretion. And I just don't know whether that would apply in a case like this, which I guess is my question is whether that's a fourth check and balance.
I think it is theoretically, but again, in my experience, when asked by clients about what can be done to vindicate what they perceive as the injustices of the investigation itself, either with a declined investigation or acquittal that the bars to pursuing the prosecutors individually are extraordinarily high. I think Judge Mukasey is right, though. These are all high achievers. They don't like to lose, and there does tend to be professional consequences for losing. I regret that we don't have more time. We're at the bottom of the hour, and I want to thank each of our panelists here. I want to thank the audience for their attention, and a reminder that the next convention event, which is a discussion of, quote, regulatory practice and oversight in 2021 and beyond, will begin at 3:45 p.m. Thank you very much for your attention today. Have a great week.